years back then. I'm thinking in this day and age when things move so much faster and all the technology and everything, it won't take us 25 years. And in fact, I'm not sure how many years it's taken us, but now we're up to 7 states that, in which you could legally marry, let alone all the number of other states where you can have domestic partner benefits in some form or other. So I predict it'll be less. So I don't know how many of you have specifically read the language of the amendment and know what we're talking about. It is very brief. It says that marriage between one man and one woman is the only domestic legal union that shall be valid or recognized in the state. It doesn't say only a man and a woman can marry, or it doesn't just say gay people can't marry. It says that a marriage between man and woman is the only domestic legal union. So therefore, that's why anybody else, that's a couple who's not married, we're not going to recognize your relationship in any kind of way. We're not going to allow you to, and in fact, we'll probably penalize you if you base some legal rights on your relationship. And so what you'll face on the ballot is the question that will be on the ballot is for or against constitutional amendment to provide that marriage between one man and one woman is the only domestic legal union that shall be valid or recognized in the state. What's not included in the amendment is a part that is in the bills, and what its effect will be is uncertain because people won't know about it when they're voting. And that is the language that says that this doesn't prohibit a private party from entering into a contract with another private party, nor does it prohibit courts from adjudicating the rights of private parties pursuant to such contracts. And that language was put in there to appease some of the opposition at the time in the legislature, particularly corporations that were saying this is going to affect our domestic partner benefits. So in order to try to get votes of some Democrats on the fence and stuff, the Republicans, this language was put in, but it's not on the ballot. So people who are voting, you're not going to know that when you're voting on the ballot. So the question is if this isn't really put to the vote of the people, is this section valid or is this not? And I just last week, I don't know if those of you saw it, and I didn't even know there was such a commission that decides how to explain amendments that are going to be before the electorate. And there is a commission that decides that, which is made up of only 3 individuals, and that's Secretary of State Marshall, it was a good list, Attorney General Roy Cooper, and George Hall, who's from the legislature, and he's head of whatever at the legislature. And I have not enough copies, but some copies here of what they voted on last week as to be an explanation. I'm not sure if it's going to be on the ballot or it's something that Board of Elections can hand out if people ask them, what does this amendment mean? But it's interesting, it's a whole page thing that can be handed out. And it does say, it talks about the term domestic legal union used in this amendment is not defined in North Carolina law. There's debate among legal experts about how this proposed constitutional amendment may impact North Carolina, and particularly as it relates to employment-related benefits for domestic partners, domestic violence laws, child custody and visitation rights, and end-of-life arrangements. The courts will ultimately make these decisions. And interestingly, I think this language tracks or brings up the exact topics that were covered in the research paper that was done by the law professors at UNC. So I just, in exact order. Of course, needless to say, both sides don't like this explanation, but I don't know how much of that is just posturing. I think, personally, I think this is great language because they really recognize that the courts are going to have to address a whole lot of issues. This isn't just, we're going to know how to proceed after this amendment is passed. And it does talk about whether there's about the private contracts issue, and does say that you may be able to enter into these agreements, but that the courts will decide the extent to which such contracts can be enforced. So if people read this, I think they're going to go, whoa, if people are sort of trying to decide what their position is or what this amendment's about. I think what I take away from this is there's a lot of questions that are going to come down the road, and that this isn't one simple yes or no for marriage. So if any of you want to look at this language, it's also, where did I get it? Actually on a political blog I can find, but I mean, I think it's good language. It's actually really good language to show people as to what are the questions raised by the amendment. So I think in order to understand the legal impact of the amendment, I think I need to discuss just briefly the current marriage laws, and then what we used to do to protect same-sex couples and families, where we are at currently, and what's going to happen if this amendment passes. And so briefly, the current marriage laws in North Carolina in terms of things like custody and child support, if you're married, you presume any children born during the marriage is the children of both those parties, even if it's not biologically the husband's child. It's presumed that it is because we don't want to have illegitimate children. And so it's an easy way to get a legal determination of that you are a parent. And certainly it also provides the obligation for child support, which is a good thing. We have a convenient mechanism to divorce if you need to divorce. Now we have equitable distribution, which means the presumption is during the time you're married, any property acquired the presumption is it's fair to divide it 50-50, no matter, and it doesn't matter whose name it is anymore. So even though the husband puts it all in his name, it's going to be presumed 50-50 unless either party can prove that 50-50 split is not fair. So it's a very, in one sense, cut and dry, clear law. And I mean, people argue over the value and what the property should or shouldn't be included, but that's what's in. It's an easy way to framework in which to decide these things, and it also provides, in contrast to someone who's not married, someone who's, and I just had these. A client in last week, they've been together over 20 years. One party has substantial wealth, like millions, the other party has nothing, and now if they're going to split up, the one party is going to walk away with absolutely nothing, and legally she doesn't have a whole lot she could stand on. And of course I said, did you ever talk about it? Did you have it? Of course they didn't have anything in writing, but did you ever talk about it, whatever? And we just don't live our lives thinking about we're going to have litigation down the road. So of course they never talked about it. And so the difference in that case, in one case like that, is millions of dollars difference between whether the one party walks away with any money or not. And if they were married, it would be a lot clearer. And so of course in other areas like inheritance, automatic rights to inheritance, you have major tax benefits, major government benefits. In fact, I wish I had more of these to hand out, but this is something from several years ago. It says, congratulations on your marriage. To honor this special occasion, the U.S. government is happy to present to you this list of all the benefits you will get by merely filling out your marriage license and getting married. And actually there's over 1,400 federal laws. That's just federal laws that benefit you if you're married. And of course, if you're same sex, you get nothing. And actually, still today, if you're legally married in Massachusetts or any other state which authorizes marriage, you still get no federal benefits. You're married for state law purposes, but you're not married for federal laws, and you still cannot get any of these. And you create a major mess between, do you fill out a tax return as a married person or a not married person? So, and I had students several years ago doing research on, so we could do an equivalent thing on the state level, and we came up with at least 150 just state laws that benefit you if you are married. So, given that same-sex couples could not take advantage of any of those kind of benefits, what we used to do, we used to have some options, and the things I passed out, I don't know if I have enough of them, this brochure that I passed out, this is from about 10 years ago, and I had some good law students who helped create this, which went back in the day when we were advocating for marriage, not battling to stop people from preventing it. And so this is about talking about equality in the hopes that we would get it just because people think it's a good thing. So then the first column is what I've just been talking about, the rights that you have merely by getting married, and this long list of rights. And the second column is the right that same-sex, how it affected same-sex couples and all the rights they didn't have. They couldn't make medical decisions. They couldn't be legally presumed parents and all this stuff. The third column is all the things we recommended they could do, like have a power of attorney, enter into a domestic partner agreement, create a joint parenting agreement, a minor's health care power of attorney, execute a will, specify various things in your will, ways to take care of tax advantages. Well, you essentially, I don't have enough copies or I would dramatically do this, can just rip off this last column, because all of these things that we have been doing for the last 35 years or more, if this amendment passes, it's very questionable whether we can do any of these things. All these legal documents that we have been providing for people, all their wills, their parenting agreements, their property agreements, all of this. So essentially, the other thing I was thinking of dramatically doing a X here, because this whole column will just be gone. And that's really one of the real major scary effects of this amendment, is not only, again, that you won't have marriage, but you won't have the ability to protect yourself like this. And this was, even though this was very expensive for people to do, this is another in terms of the different impact on whether you can marry or not. People would have to pay thousands of dollars in attorney's fees if you want to do the whole wills, property agreement, if you have children, all the children issues. You're spending all this money, taking all this work, just to get, again, what a marriage license would have automatically given anybody else. And one other thing that we are no longer able to do, just to show where the trend is going in North Carolina, is we used to do second parent adoptions here, starting in North Carolina, thanks to many people here in Durham who helped start that and were willing to put their families out there. And we had, from 2004 until last year, done over 200 adoptions. So there's 200 children in the state who had two legal parents instead of one, until this case came down until our Supreme Court said we could no longer do them. So that's really, so again, then we're back to now all we can do is these things, and now we're back to I can't help create two legal parents. I can do joint parenting agreements and stuff until this amendment passes, and then we can't even do that. So what will happen if other things that will happen if this amendment passes? The words that come to my mind about it are devastating, and it will, as I said, it will eviscerate all these protections that we've done. And then in the first couple of years, we will have major years of litigation over how do we determine what is domestic legal union, which even the commission here acknowledges has not ever been determined in this state. So we're going to have years of figuring out what does that mean. And we can look to other states, like Idaho passed a constitutional amendment in 2007, South Carolina did in 2006, and in both those states they have yet to make any final determinations on various issues that have been raised. Their cases are still winding their way through the court, and that's several years later. The one other state that's passed one but has had some litigation is Michigan, and theirs have come down on the side of very restrictive, that you absolutely can't do all these other kinds of things. I mean, they've really come down on the side of this is a big prohibition against unmarried couples. So in the meantime, while all this litigation might be going on, I think you're also going to see people literally leaving this state. I have had several clients, more than one handful, that have literally moved from North Carolina so that they can go to a state where the second parent can adopt their child and they can protect their families. Some have been fortunate enough to go and come back, and thank goodness, come back and live in the state, but many good people have just left the state to protect their family. And then there'll be the confusion for those who do stay, and there's also the opportunity for some people to take advantage of the situation and literally, which we already have seen in the custody arena, people move to states where the laws might favor their position. If they want to deny the second parent right to custody, they move to a state where the laws are not so good, and that they'll have a stronger case. So we see a lot, there's some very some significant litigation out there where we show already that happens.